Mr. Patton, can you state your name, please?
Andrew Spencer Patton.
Thank you. What are we doing?
Your Honor, we have reached a resolution of this matter. Mr. Patton is signing the plea form and the advice of rights form. The people have offered to reduce this to the use of cocaine, a 1-year misdemeanor.
He's going to plead guilty to that charge.
Yes, he is, Your Honor.
All right, the plea form that I have in front of me now indicates that the defendant will be pleading guilty to the charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed.
That is correct.
That's the court's full understanding of the agreement. May I have it sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Andrew Spencer Patton.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine.
Yes, sir.
That's a misdemeanor punishable by up to 1 year in jail and a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case,
Yes, Your Honor.
and that you would be sentenced before Judge Perry in the 15th District Court. You
Yes, Your
understand that? Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce
No, Your Honor.
you? You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you believe that you're guilty?
Yes, Your Honor.
May 16, 2025, at the location of North Huron Street, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was cocaine?
Yes, Your Honor.
Sir, if I accept your plea, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
And have I complied with the court?
Yes.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
February 27th at 8:30 before Judge Perry.
February 27th, 2026, 8:30
Your Honor, may I address bond?
before Judge Perry, as to bond.
Thank you, Judge. Your Honor, Mr. Patton is in custody on a bond violation for failure to test. It's my understanding that he was reporting as directed, but didn't have the funds to test. He also believes there was some discussion at the time that the bond was set, indicating if he was not able to afford testing, that he would not be in violation. So we are respectfully asking if Your Honor would reinstate the bond. Thank you, Judge.
Any response from the people?
Here's the question.
Are you going to be able to test?
Yes, sir. I mean, I can't afford it, but I can test clean. I can't afford it.
Well, you're going to have to find a way to.
I can find a way.
to test. Because if I let you out, we're going to end up in the same boat again. If you don't go over there and don't test.
I can go test. I can either pan out or do something to make that money up, but I can. Yes, sir.
I'll grant the motion for a bond reduction. Previous bond is reinstated with
Thank you,
its
Your Honor.
conditions.
Thank you, Your Honor.
Thank you.
Jackson on behalf of Mr. South. Please state your full name for the court. Kadena Gill Self.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
You're waiting. You just got appointed. You're waiting video discovery.
Correct.
Is that on its way?
We have it, Your Honor, so it should be.
Probable cause conference will be adjourned then to February 12th.
Your Honor, I'd like to make a bond modification motion.
February 12, 2026, 9 a.m. Yes, it's the bond.
Your Honor, Ms. Self is being held on $1,000 cash bond. I'm asking for a reduction to a personal bond. It's reported to me that she and the alleged victim do not reside together. He has a different address, so she should be able to return home. And or may not be able to see. She does have a cast on that she will need to go to a physician to address, and being incarcerated, I'm afraid that she won't be able to do that to get it off in a timely manner.
Response.
Your Honor, at this point, I would object. On our bond, we requested 25,000 cash period. This involved Ms. Self stabbing the victim in the shoulder with a screwdriver, hit 5 puncture wounds that officers saw. She was also very irate and aggressive at the scene when officers arrived and were berating the victim and then had to be carried to this car. So I expect that this could potentially be other charges in the future for RNO, but at this point, I would object.
Anything else?
Yeah, I would just say that it was a highly intense situation, and berating, calling someone names does not rise to the level of incarceration, I believe, or additional charges. Calling someone names isn't enough.
Well, the
But for that's
stabbing with a screwdriver, that would do it, wouldn't it? You don't need to say anything.
just-
Motion for bond reduction denied. Bond will continue. Thank you. She's lucky I won't raise it at this point. The adjournment. Have you seen the progress report?
Yes, I reviewed it with my client this morning, Your Honor.
Why do I have cocaine showing up in her system?
Because
Up until this moment, the hearing seemed routine, but when the judge reviews the drug test report, things suddenly take a serious turn. The defendant claims the cocaine stayed in his system from earlier use, yet the timeline of the test tells a very different story. And now the judge is about to break down exactly why that explanation doesn't add up.
Oh, sir. When they test over there, they don't do it the levels. So I've been getting high for 48 years.
What?
Yeah. And so even though it was like, I think the last time was like New Year's Eve or January 5th, one or the other. But you don't show levels, so you don't show it going down, down, down. And therefore, if you got cocaine in your system, you just got cocaine in your system. That's how it is. But that's not okay, because it could be in my system for a long, long time, even though I don't get high.
Okay, so just so I'm clear what you're telling me,
Yes.
that on January 5th, you
Mhm,
tested positive for cocaine.
mhm.
And that was just,
And I didn't
that was just
expect,
something in
it
your
should
system.
not have been.
It shouldn't have been there.
Right.
It's just stuck in your
But you
system.
guys don't do
And
it
then-
by levels.
What?
You don't test it by levels to see if it's going further and further.
Okay, so then the next time you're supposed to test, you missed the test.
Huh?
Then you missed the test.
Oh, I didn't have $12.
Okay. And then the next test, almost 2 weeks later, you're testing and you test positive for cocaine. And so, hold on before you, because I want to make sure I've got your story. And so you're telling me that the second test for cocaine was really the same as the first test because it's just stuck in your system because you've been doing cocaine forever.
What
I
I'm
don't know
saying,
who the heck you are, but if you start yelling in my courtroom, you're gonna be going with her.
okay, this will happen on the 5th, to be honest.
What? What happened on the 5th?
I said that, wait, what happened? Let me think.
I don't know. Go ahead, think about it.
Right. What I'm saying is, on the 5th, I was dirty. I had used, like, not that far from there. But I was scared to say so because I was scared to say so. So then the next time I didn't have the $12. And the next time it
So
was
hold on,
still
that's what I was getting at before your fans started yelling out from the.
my sister. She here
Okay,
from
all right, but
out of town.
so you're telling me
Mhm.
this test that showed up positive, you didn't use cocaine,
Which one?
the 20th,
The 20.
last
no,
test.
No, I had.
You had
Since
not
the
used
fifth.
any cocaine,
No,
even though you've been using it for years.
right. Right. It should have been clean. I'm saying, I don't understand why it was dirty. But the problem is this, sir. You guys don't check the levels. So you,
Oh,
I
can check levels,
wish
but
y'all
not
would.
about, well, I can get the levels.
Okay.
That's not a big deal.
Okay.
The problem is because you missed the test,
Uh-huh.
if you did a little bit of cocaine, it'll look like it's going down, but you didn't use cocaine still.
Oh,
You should not be testing positive for cocaine 2 weeks later. That's the bottom line.
so no.
Grant an adjournment in this matter to February 5th, 2026, 9 a.m. That's 1 week out.
Your Honor,
You're not available that day?
correct.
That's fine. I'll set it on the 12th. At this point, the defendant's bond's revoked. She's remanded.
Damn.
What'd you say?
Excuse me. I was saying my
You
sister.
know, you need to take yourself on out. All right, we're back on the probes matter.
Morning, I'm Raymond. Caden, sign that. Michael Gaddius, public defender on behalf of Mr. Probst, Your Honor. State your name.
What are we doing? Thank you, sir.
Your Honor, these are going to be waivers. I have gone over his rights. He's executing the form now. I've gone over
Sir,
with Mr. Probst.
You're waiving your right to a preliminary examination.
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that's alleged to have committed it. You committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further
Yes, sir.
resolution. People also waive their right.
Yes, Your Honor, there was an offer I can put down on the record.
Yes, go ahead.
The offer was completed to the filing 1391, motion for dismissal of filing.
All right, good.
That is correct, Judge.
Preliminary examination having been waived in both of these matters. Defendant is bound over to circuit court.
Your Honor, in terms of arraignment, we'd waive reading, stand mute in the charge.
Defendant having waived former reading, standing mute, court will enter a not guilty plea. Pretrial will be set for February 11, 2026, 1:30, Judge Conlon.
Your Honor, if I could be heard on bond.
Yes.
Your Honor, I've had a chance to speak with Mr. Probst about this. I've reviewed the file. Mr. Probst was remanded at his last probable cause conference. He had missed some tests and had tested positive. The positive tests, looking at the violation, were from when he was first arrested. He reports he got a personal bond sometime around December 29th. The missed tests, he reports resulted from a stay in the Wayne County Jail where he was, obviously unable to test. He then reports having gone to community corrections. They indicated that they did not have any record of him needing to be there, and that's why he didn't test on the 29th. I'd ask the court to release him. He does report that he does have a place to stay in gainful employment. I have reached out to the, he gave me a number. I've reached out to the employer. They haven't gotten back to me yet. So, but that's kind of where things stand, Judge. He reports that he would test regularly in this matter.
That's not what my file reflects, his rendition of things. But motion for bond reduction tonight. Bond will continue. Bring it up.
Thank you, Judge.